Hello, welcome to Miss Kama's Business English class, and today we're gonna talk about the key elements of a contract and the meaning behind them. Let's first focus on what a contract is. The contract is a promise, but this is legally enforceable, which means that if there is a breach in a contract, then the law can allow a remedy for that breach. And remember, each contract has got its key elements, beginning from an intent to make one an offer and consideration for both parties, to an agreement of a specific detail of a contract which leads to acceptance, at which point the contract is legally binding to both parties. Well, now let's focus on the contract details with specific definitions. Now it's obvious that the contract is a legal binding agreement among two or more parties that's enforceable by the courts. And most contracts are enforced by state common law. And this includes contracts for employment, real estate, insurance, business contracts, or intangible items. Function of contracts are being fundamental to business and creates rights and duties between parties. In order to sign this legal relationship paper with people or businesses, we need parties. Parties are those who wants to do something together, and parties consist of two sides: a promisor who makes the promise and a promisee who accepts the promise. In order to have the proper contract, we need requirements for that contract, and it begins with the mutual assent. To engage in a contract, both parties must show mutual assent. The parties do this by showing words that they have both agreed to enter into a contract. Generally, there is an offer by the offerer of the contract and acceptance by the offeree of the contract. Considerations. At least one party must exchange promise of goods, funds, services. One party in unilateral contract or both parties in a bilateral contract. Legality of objective. The contract must not consist of crimes and torts. A contract killing would be obviously not to be held up by the court cause murder is illegal. Capacity. Parties of a contract must have the legal ability to enter into a contract. A blind man, for example, could not make a contract with a mole to monitor the security cameras because he would not have the ability to fulfill his promise. Consideration, promise consideration we call it. Capacity can also be used as a defense in the courts if a party of a contract enters into the contract while intoxicated. Or he or she may be able to use this as a successful defense. Let's remember together: requirements for a contract are mutual assent, consideration, legality of objective, and capacity. Now it's time to talk about them in detailed version. The contract. In a contract, intent refers to the determination of parties to act or perform in a particular manner. It's a state of mind with which the parties entered into the contractual obligation. Let me explain it. It means we need an intent in order to make an agreement between people. The intent is something we need to have while signing this paper. Remember, without an intent to both sides, there can be no contracts. If you have got an intent, you should have an offer And it means when you propose a contract to a businesses or to people, you're making an offer. That offer may be accepted, rejected, amended, or sent back as a counter offer. Accept this offer. Maybe you have heard this. Offer and acceptance are part and parcel of any contract. In contract law, an offer is a promise in exchange for performance by another party. An offer, as I said before, can be revoked or terminated under certain conditions. There are also times when an offer can be negotiated to create a counter offer. Good. What are the considerations? Considerations are promises or goods, funds, services, performances, no performances. Simply, the consideration as something of value or an item of value or benefit for both parties, which should be included into every contract. Intent, offer, and considerations leads to verb called agreement. An agreement is the second essential step in creating a contract. An agreement represents the acceptance of an offer made by another party. When an agreement is reached, it means that the two parties to a contract have agreed to terms and have decided to become bound to perform the actions in the contract. Agreement happens after the acceptance, and acceptance takes place when both sides agree on contract. We don't fulfill our duties according to the contract, and it leads to the repudiation, which is a term when a party repudiates a contract by expressing an intention not to honor his obligations under the contract or by taking action that demonstrates he will not perform. Frustration, which we can come across during the contract period. One of the parties, or maybe both of them, cannot fulfill their obligations, but it happens for unseen reasons, and we call this frustration. We can determine that the frustration is something when a contract is a frustrated way after the contract was concluded. Unforeseen events occur which make performance of the contract impossible, illegal, or something radically different from that which was in contemplation of the parties at the time they entered the contract, and neither party must be at fault. Let me explain it again. The frustration happens without the fault of either party. If there is repudiation, frustration, obviously there are some problems, and when contracted parties try to solve their process, they settle the dispute. The settling the dispute can be done in and out of the court. Of course, first businesses or people try to arbitrate it in order to reach the solution without the help of code, and this process is called arbitration. Arbitration is a method of resolving disputes outside of court. Parties refer their dispute to an arbitrator who reviews the evidence and listens to the parties and then makes a decision. Arbitration clauses can be mandatory or voluntary, and the arbitrator's decision may be binding or non-binding. Well, damages. All reputations and other frustration, maybe other problems, bring damages with themselves. At the common law, damages are a remedy in the form of monetary award to be paid to a claimant as compensation for loss or injury. To be recognized at law, the loss must involve damage to property or mental or physical injury. Poor economic loss is rarely recognized for the award of damages. We understood that the damages can be awarded as a form of money by the judge to the party who can prove its claim. Okay, it's time to repeat all the main principles together. Let's begin with intent, offer, consideration, acceptance, parties, representation, repudiation, frustration, settling a dispute, arbitration, and award of damages. Now, it would be a great idea to talk about the terms and language found in the contract, and we should begin with the terms. Come to the term. The terms are detailed points of contract where both parties are agreeing on. When they come to the term, it means they agree on all these points. After this, it's time to ratify the document. Ratifying a contract is the act of approving the terms and conditions that are being spelled out in the document. After all, having a signed contract isn't always enough. Additionally, any situation in which you may be asked to ratify a contract provides you the opportunity to then refuse it. Ratifying the document is normally done by signing a paper version. Without prejudice is another term used in the contract. What is this? The term without prejudice refers to the legal privilege attached to communication that is specifically used for the purpose of negotiating settlement, and it restricts any such communication from being relied upon in court proceedings. In other words, without prejudice communication are inadmissible. We understand that the statements which were done by contracted parts without prejudice cannot be used as evidence during the legal situations. Contract conditions. This means that each of the parties is obligated or required to perform a duty under the contract. The contract conditions determine the parties' obligations. A condition is an act or event that affects a party's contractual duty. If conditions aren't met, your contract is breached. The warranty is another term. A warranty in contract law is a promise or guarantee from one party to another that facts are true and reliable. A contractual warranty is obligation that the facts relate to the subjects of the contract are true. Maybe warranties are less important than the conditions, because when you don't fulfill the warranties of a contract, your contract is not considered as broken or breached. it's perfect time to talk about the types of contracts. The first type is bilateral contract, is where both parties have mutually agreed to promises considerations. Let me give you an example. Imagine Jim owes Bob yard work and Bob owes Jim $50. They both have considerations, therefore it's bilateral contract. Unilateral contract. When offerer wants performance in exchange for his promise. When contract is formed when offerer performs. The good example is contest. Revocation of offer. Modern view is that offer is irrevocable once the offeree substantially performs. Another type is express contracts. Express terms of contract are set forth either in writing or orally. Implied in facts based on conduct. Plaintiff furnished service or product. Plaintiff expects to be compensated. Defendant had a chance to reject and did not. Implied in law. We call it quasi-contracts. Fictional, created by court to avoid unjust enrichment. Express contracts, as we see, are more detailed, and we can see or hear them during the negotiations, and they are more clear. They are much clearer than the implied contracts. Liability, the legal responsibility of the parties. Under contractual liability is the liability that you assume on behalf of another party as a result of a contractual agreement. You might have heard it called the hold harmless clause in some legal settings. Basically, you are assuming the risk as you work with another party. And very common term with it happen as joint and several liability. Joint and several liability is a rule followed in some states in which two or more parties can be held independently liable for the full amount of a personal injury, plaintiff's damages, regardless of their respective degrees of fault. Simply, joint and several liability means that each one in the contract will fulfill its obligation individually. One more type of contracts is executed contract. A contract that has been completely fulfilled is considered as an executed contract. Executed contract itself is a contract that has not yet been fulfilled. And both these contracts are followed by formal contract. A formal contract is a contract that is legally binding due to the particular form or mode of expression. We have talked about the specific terms of a contract, which were terms: come to the term, ratify an agreement, without prejudice, legally binding. And we learned the types of contracts. Now it's time to firm our knowledge with some quizzes. Thank you for listening.